Please be seated. Good afternoon to everyone. Welcome to the First Court of Appeals. We have one case on the docket this afternoon. It is 01-24-00789 Darryl and Darresha George versus Barbers Hill Independent School District. Starting with appellant counsel, can you please make your announcements? Will you both be arguing or just one person?
Both. I'm going to take the initial 10 minutes of our first 15, and Ms. Booker will take the remaining 5, and then we'll reserve 5 for them.
Very good. For the district? Thank you very much. Just some housekeeping matters. The timekeepers in front of you, when the light is yellow, that means you have 1 minute remaining, and of course red can stop. If you're in the middle of answering a question, please feel free to finish your answer. Before we begin, I want to thank everyone for the briefing and all of the materials that were submitted. They were very important and helpful to us in addressing the issues. We know that this is an important case for the parties, and I just want you to know that we have taken great care to review the filings and familiarize ourselves with the record and to set this case as soon as we were able to do so. We have studied all of the materials that have been presented, and we did read the brief, so we don't need a recitation of the facts. We are familiar with the facts. It would be more helpful to us if you just go straight into the legal issues. As the parties know, the district has filed a suggestion of mootness in this case, so I think it would really help us if the parties can start with that issue first and walk us through it. We'll also be able to, we'll be entertaining, of course, also arguments on the merits of the claim. So I know there's a lot to cover. So Mr. Drummond, we've given you very brief time. If the parties feel that they need more time to flesh out these issues, we will make sure that we allocate any additional time to the district. The most important thing for us is for you to guide us in these important issues, and we want to hear from the parties on all of these issues that are facing us today. With that, we're ready to hear from appellants.
Good afternoon, and may it please the court. My name is Dylan Drummond. It's my honor to represent Darryl George and his mother Darresha, alongside my outstanding co-counsel, Allie Booker. I'd like to offer a brief opening statement, and I'm happy to answer any of the court's questions. Here, the district and the superintendent have judicially admitted that Mr. George wears his hair in a hairstyle protected by Texas Education Code 25902, admitting both in their pleadings and under oath that he wears braids and twists, as well as that his hairstyle is commonly or historically associated with race, both touchstones under the statute. Yet the district nevertheless discriminated against him by confining him to in-school suspension during his entire junior year of high school for exercising his statutorily protected right to refuse to cut his hair. At bottom, the district purports to invent an exception to the statute that it does not contain, and this purported exception of hair length would impermissibly thwart, neuter, and undermine the statute if this court lets it stand, because the record demonstrates that the very types of hairstyles that the statute protects, that is locks, braids, and twists, require length greater than that permitted under the district's male hair length policy in order to be worn at all. In short, if the district's male hair length policy is upheld, no school district in Texas would ever have to comply with the statute. With that, I'm happy to take the court's questions.
Well, if you can walk us through mootness issue first, that would be really helpful.
Absolutely.
Help us understand why, despite Mr. George's graduation from high school, the issue here is or is not moot in this case.
Absolutely, Your Honor. I'll start with the lowest hanging fruit first from the reply brief that the district filed a couple weeks ago. First, they assert that Texas Education Code section 7057 is a provision that enables an administrative appeal up through the Texas Commissioner of Education of acts that a school district commits. And they assert that because that exists in statute, we are not able to bring our deck action claim. That argument fails for several reasons. First, and I think probably foremost, The district has neglected to inform the court about subparagraph A1 to that section, which explicitly states it is not exclusive. A person is not required to appeal to the commissioner before pursuing a remedy under a law outside of this title. So you can proceed on parallel tracks first. Second, they cite to an Austin Court of Appeals decision for their purported holding. Of course, that's not binding on this court. It's merely precedential. And two, that decision doesn't say anything more than the standard holding that you can't achieve through a deck action, which you could achieve through a substantive statute. So a breach of contract claim, or you can interpret a contract which you can't find through a deck action that someone breached it. Here, the claims that the Georgias brought through the administrative provision merely dealt with the district's denial of the religious exemption that Mr. George applied for in order to wear his hair.
Well, we agree with you that we can proceed on parallel tracks, though.
Great.
Hone in on the collateral consequences issue, because that's really, I think, what the court is trying to determine here. Are there collateral consequences that will persist, notwithstanding any finding of mootness, that there is no live controversy? And specifically, if you could address the district's point in the reply brief or response brief to the mootness issue, that any collateral consequences have to stem from an actual judgment and not from the underlying facts itself in order for the doctrine to apply.
Absolutely, Your Honor. To address that issue first, to me it's a bit of a straw man. It's half a dozen one and six of the other. The bad conduct is what collateral consequences bases its public policy on, but it only has effect because it's been enshrined through the jurisprudential vehicle of the final judgment. So the conduct and the actions that we're complaining about that have left Mr. George with concrete disadvantages and disabilities that have, one, occurred and two, will persist. It's from the Marshall case, Texas Supreme Court 2006. Even after judgment is vacated, those only have resonance here because the final judgment in effect consecrates them.
What final judgment do you want? Perfect world, how would you write it? What do you want to say?
Absolutely, Your Honor.
Not the opinion, the judgment.
This is my favorite question. No, we are seeking a declaratory judgment that the district's male hair length policy violates Section 25902 of the Texas Education Code. And that's a bit of a merits argument, but just briefly, because the exception that they have invented that is not contained in the Texas statute itself would negate the ability of anyone to wear these protective hairstyles. They require a length of hair to wear braids, locks, or twists that you cannot wear under the district's male hair length policy. So that obviates and moots the entire application of the statute. So is
your argument that we should be looking at the statute as applied to all students or just as to this particular student?
Well, the male hair length policy applies to all males in the school district.
But are you asking us, are you saying that it's not moot because we somehow have the ability to adjudicate this as to other students?
Well.
And if so, how?
I would defer, well, I'll say a couple things. One, only Mr. George is the appellant here. We have not made a class action argument as the district has asserted in their brief. But I do note for the court that the district, I think, tellingly and revealingly noted in their suggestion of mootness that the court's determination of this issue will affect all the male students in the district, not just Mr. George.
But how is there a live controversy as to Mr. George?
Well, so on several fronts. To address the issues first that Justice Reeves Malloy asked about, there are two different constructions of the test for when collateral consequences, when the exception applies, both from Marshall 2006. First, concrete disadvantages or disabilities have in fact occurred and will persist even after the judgment is vacated. Here, the evidence in the record is robust to support this. The district, again, in their reply said that we didn't cite any evidence for this, instead only citing a briefing. The only briefing that we cited was their original petition for the fact that they sued their minor student, Mr. George, instead of complying with.
Where do we find the evidence of the collateral consequences in the record?
Right. So if the court turns to pages 1203 and 1204 of Volume 4 of the clerk's record, that is sworn testimony from Mr. George. And I'll just read you a few of the excerpts. I'm being punished and placed in detention and alternative learning centers. I have not had regular instruction since August 30th of 2023. My grades are suffering. My will is suffering. I'm being completely ostracized. I've had to seek mental health treatment and I feel like I'm going crazy. I'm being harassed by school officials and treated like a dog. I am mentally hurting and my heart is hurting. I would also direct the
Okay,
court.
can I just
Yes.
pause you for a second? So if, let's say we agree with you that there are collateral consequences
Yes.
and that is evidence of collateral consequences, what do we do about this language from Justice Young in 2025 in the Texas Department of Family and Protective Services? But a dispute remains live under the collateral consequences exception only if the otherwise moot claim itself is the source of a sufficiently concrete collateral consequence. If the consequence would exist regardless, then the case is moot. So how would these consequences not exist regardless, these ones you just mentioned?
The consequences only exist as a matter of jurisprudential reality because they are contained and enshrined in the final judgment. So
Why do they only exist? Because they're in the, like, if we vacate the judgment.
for purposes of analyzing whether the collateral consequences exception applies, is the scope there. The facts, of course, will always remain, Your Honor, but their applicability to this case and to invoking the collateral consequences exception is required because they are enshrined in the final judgment. They're permitted by the final judgment.
Let me ask you a follow-up question. If we agree with the district that the case is moot, we would not only have to dismiss the appeal, but we would have to vacate the lower court's judgment as well.
Yes, sir.
If the consequences are enshrined in that judgment, would vacating the judgment then ameliorate those collateral consequences?
Not under the collateral consequences exception, Your Honor.
Why not?
Well, let me get to the second construction of the test, as in Marshall, to see if that helps answer the court's questions. This goes to the stigmatization prong, that the collateral consequences exception applies, quote, when prejudicial events have occurred whose effects will continue to stigmatize after dismissal of the case as moot. Here, I think the facts are even stronger to support the stigmatization prong. First, part of the reason why we cite so liberally to the former justice of this court in his decision on the Southern District of Texas, which involved the same superintendent, the same district, the exact same policy language as is at issue here, is because you need to understand the sequence of events. The district, when it elected to sue Mr. George, instead of complying with the statute on September 1st of 2023, knew what a media maelstrom that would unleash and what a digital footprint it would permanently affix to Mr. George. They had just been through global media coverage of the DeAndre Arnold case, which they are still suing. They're still involved in that litigation now. So they were well aware that by them suing their own minor student, this would permanently stigmatize him for the rest of his life. There's no escaping his name forever being tied in every database to this dispute. So that's the first evidence
How does
here.
that make the consequences from the claim? Help me understand whether they're from the claim or not based on that. Because this Justice Young language just this summer says the consequences have to be from the claim. So are those from the claim or not?
Well, yes, Your Honor. I mean, I think that our claim for declaratory judgment is seeking to overturn the final judgment, and it's only seeking to protect Mr. George, but as has been evidenced by the treatment of Mr. Arnold and Mr. Bradford prior to Mr. George by the district, to protect students that come along after Mr. George and Mr. Arnold and Mr. Bradford have graduated. Let me just note one other fact here that I think should be pertinent to the court's analysis on as far as stigmatization goes. The district took the additional extraordinary step of buying a paid advertisement in the paper of record of the fourth largest city in the United States, the Houston Chronicle. We document in our briefing the Houston Chronicle boasts that it has a readership of 3 million in Houston, 12 to 15 million in Texas, and 150 million throughout the nation. In direct opposition to Mr. George and to this litigation, the district superintendent bought a paid ad. I don't know how much that cost the taxpayers of the district to state, one, falsely that they've complied with the statute, but they said in larger text than anything else that complying with the statute is a lesser goal than the conformity which they have asserted is achieved by all the district's male students complying with the male
Mr. Drummond, so those, I agree with you, are the negative consequences that stemmed from the lawsuit and from the policy being applied. I mean, there's no question that these things happen, and the testimony is in the record. As I read, and maybe help me understand this better, as I read collateral consequences, we're looking at future potential consequences.
Yes.
It's not backward looking. So as I understand your argument is that there's still this issue that there is still school records that reflect the in-school suspension that may impact his ability later, for example, to apply to college. Has he in fact had to disclose any of these school records to any third party?
Well, if he had, that wouldn't be part of the appellate record, Your Honor, so I don't think I could augment it. But I know the district has said that that's a red herring because they can't disclose these records. That's why the decision to sue itself, that's why the decision to take out a paid advertisement in a major newspaper are the stigmatization. Yes, to the extent that those records are ever discoverable through some means that we may or may not be aware of now, that will absolutely stigmatize.
But what about on the common application, perhaps? What if it says, have you been suspended? And you have to answer yes or no. Is there anything in our record on that?
No, Your Honor, because all of that has happened post when we filed this appeal and when the record was
Can you remind me? Did in the countersuit, did the appellant here seek any remedy with respect to those records that the school was maintaining? In other words, it was not just a DEC action, but was there any requested relief as it pertains to school records? Any request for expungement or any other affirmative relief?
I do not believe so, Your Honor. There's injunctive relief that is still outstanding. There's declaratory relief, of course, attorney fees and costs, a request for jury trial. Originally, there were federal civil rights claims, some constitutional claims, breach of fiduciary duty, intentional infliction of emotional distress. But I do not believe that there was an expungement claim as part of that.
So coming back to earlier, we were discussing that you said the policy would affect all males. Our ruling, in theory, would affect all male students. But then this is just a case concerning Mr. George.
Absolutely.
If this were moot as to Mr. George, is there any way for us to reach the question anyway? Or
if the court finds that it's moot and it vacates the decision, then I think that's the final decision of this court. It will rest on the parties to see if we seek to have review by the Texas Supreme Court. But
no, I'm sorry, that's not what I'm asking.
Yes.
I'm saying if your position is that you're just asking us to compare the two texts, right? Look at the policy text and the statute text.
Yes.
And you're saying that affects everybody. My understanding is we still need a live dispute between the two parties at issue, but I want to understand your position on that.
Absolutely. Well, first, I think collateral consequences exception applies, but I think even more basic, the easier call for the court is that we have outstanding claims for attorney's fees, which is in the grassroots decision.
How could that resolve anything here?
Well, I can just go by the language that's in the grassroots decision. It says a claim for attorney fees, quote, breathes life into a suit that has become moot in all other respects. That's pretty clear.
But it would allow potentially an attorney's fees claim to remain live, but it wouldn't necessarily make anything else live. Number one is my understanding. Number two, I thought you don't have any appellate issue on attorney's fees.
Well, we have claimed fees below in the trial court, and of course under Chapter 37 of Civil Practices and Remedies Code, you don't even have to be a prevailing party in order to be awarded fees for a DEC action claim.
But what is live right now on attorney's fees on appeal?
We have an outstanding claim, as the court knows from having reviewed the record, and we're thankful the court's been able to do that. This was decided very early on. I think we had 9 days notice from when the court sent the notice for motions to be heard to when motions actually were heard. So far short of the 21 days for summary judgment, far shorter of a 45 days for final bench trial. So the record here is not as developed as it might have otherwise been because it was rushed to trial. So those are all issues. If the court doesn't see fit to render a declaratory judgment, if it remanded, then that would give us the space and the ability to try to develop this record further.
Mr. Drummond, unless we have any more questions on Junis, we'd love to hear your arguments on the merits.
Thank you, Your Honor. And thank you for the time. Now, I do want to reserve 5 minutes for
Yes.
You're not going to get pension.
We'll just keep track of the time.
Okay, good.
So here you have your rebuttal,
This is a big case.
Good.
We're going to take all the time we need.
Thank you. We certainly do appreciate it. So, as I mentioned briefly, this is just a statutory construction case. It's not partisan. It is not political.
Hold on, I'm sorry. Could you make the
She-
time
she's,
keep clicking?
she's keeping it. She's
But so they can see? Could you make the time keep?
This won't show up. It doesn't
Okay.
have that ability.
Okay, sorry. I thought it.
I will stop as soon as you'll tell me to stop.
No, I'm
Please.
sorry. We just
We're
wanted you to
unlikely to
know.
do
I
that.
wanted you to know your timing, but.
Yeah,
I
unfortunately,
apologize.
our time doesn't click up, but we have someone keeping time for us.
This is all going to Miss Leon's time. So here, I think it's crucial for the court to understand that in the final judgment, both in the findings of fact, conclusion law, and in the final judgment itself, the court admits this. The statute is, quote, silent on the question of length of hair for male students. The court also acknowledges that the statute, quote, could have been written to provide this exception, but it wasn't. The court is admitting explicitly in writing that the statute is silent, and it's on the basis of the silence that the court found that the hair length exception that the district has invented can stand. But that is not how statutory construction works in Texas. In fact, that's exactly
Why
the
not?
opposite.
We can't write words in, so if it's silent, we can't add words.
Because by creating an exception that the statute does not contain, you are writing words into the statute.
How are you creating an exception?
Because the statute contains no exception at all.
Help me understand this. Okay, is the protective style, there's a definition of protective style in the statute, at least that it includes braids.
Yes, sir.
Is length part of the protected definition? In your opening, you said it, I thought I heard you say it once. Help me understand why it is.
Length is not mentioned in the statute.
No, understood, but I thought you said that length was.
The reason
Part of
why,
protected.
under pure statutory construction, the court should overturn the final judgment, render declaratory judgment in favor of the Georges, is that this exception that was created out of whole cloth obviates the entire operation of the statute. Texas Supreme Court's been very clear that you are not allowed to do that. Hughes in 2008, changing the meaning of the statute by adding words to it is a legislative function, not a judicial function.
Right.
So if the legislature wanted to write any exception, whether it be hair length or hair color, it could have done that. It did not. There are no exceptions to this statute. So a subordinate political entity has no jurisdiction, has no authority to write one into the statute, nor does the court system.
Right, so the court
Yes.
system can't say you can't have braids or something like, something as the statute protects, but I'm trying to understand take this hypothetical. Let's say somebody in a different case has a protective hairstyle that involves what is protected is that their hair is long, right? Like they have hair
Yes,
to the
sure.
ground or something of the sort. In that case, help me understand how the analysis would work in that case.
Sure. I mean, and again, I can only refer the court to what the Texas Supreme Court has said on this, and none of these are novel concepts. These are not new concepts, as the judges know. This is black letter, basic statutory construction. So let me start there. If you go to Longoria, which is 2022 of the Texas Supreme Court, the legislative intent is, quote, the alpha and omega of the interpretive process. If you go a year before that to Texas Education Agency 2021, it's the pole star of statutory construction is legislative intent, which we determine from the enacted language. You cannot determine intent from language that is not in the statute.
I'm sorry to interrupt, but I really would love it if you can help me understand the answer to that question. So I'm trying to understand how the definition of protective hairstyle works. So if the protective hairstyle is, if what is protected in a certain instance is in fact the length. So let's say that everybody agreed in that case that what was protected was the length. Then presumably there would be no question that the policy would be violating the statute in that instance.
The best way I can answer that question, Your Honor, is from the statute's language itself. Any student dress or grooming policy adopted by a school district may not discriminate against a protective hairstyle commonly or historically associated with race. And as you mentioned, it defines protective hairstyle to include braids, locks, and twists. Again, we have no factual dispute here that Mr. George's hairstyle was a protective hairstyle, both because the district has admitted it was braids and twists, and that it was commonly and historically associated with race. There's nothing in there about length.
Okay.
But practically, In order to wear a braid, a lock, or a twist, you have to have hair longer.
What in the record shows us that?
We have sworn testimony from the bill's authors, from the bill's co-authors. I believe there's 5 or 6 affidavits in the record that all talk about and are explored at length in our briefing. That talk about how in order to wear a braid, lock, or twist, which this statute protects, your hair has to be longer than that which is allowed by the district's male hair length policy. It would have to extend below the bottom of your earlobes, below your eyebrows, and below the top of your shirt collar.
So what you're saying is there's testimony in the record that the hairstyle that Mr. George was wearing, as he was wearing at the time, is historically associated with race, and that issue is not disputed by the district.
Yes, and in fact, I'm happy to give you the actual cites to the record. They are in our briefing, but yes, both the superintendent and the district in briefing and in sworn testimony have admitted that Mr. Arnold wore braids and twists, and that the hairstyle that he wore was commonly or historically associated with race. So there's no fact issue. That's why this is a purely legal issue. I believe the court can render.
But are you asking, again, I'm coming back to my as applied versus kind of writ large. Help me understand that. Is the point here that as applied to him, with his particular hairstyle, on what was conceded here about the protected hairstyle, that the policy conflicts with the statute?
Yes, sir.
Or is your point that just writ large, when we compare the two, they conflict?
Both. There's evidence in the record that the hair length of Mr. George's hair that he was discriminated against by being placed in in-school suspension his entire junior year was the length was part and parcel of him being able to wear braids, locks, and twists. But as people
Why
know,
couldn't he wear short braids, locks, and twists?
Because the district's policy that they changed halfway through the school year in 2019 with the DeAndre Arnold litigation, there's testimony in that case by Judge Hanks that shows that had never happened before. They never changed a hair length policy during the middle of a school year, but they did then, and they changed it to add when let down. So what that language does, look at our demonstrative here. Obviously, Mr. George there has braids, locks, and twists that are longer than below the bottom of his earlobes, below his eyebrows, and below his shirt collar. But he had bound them up. That's what he did every day at school, to bind it up to try to comply with the school's male hair length policy. The addition of the when let down language means that you can never have hair, because it doesn't matter if you have it bound up under the language of that policy. So you cannot physically make a lock, braid, or twist if your hair is not below your eyebrows, below your earlobes, or above the top of your shirt collar. That is why, if the exception that the district had invented and the trial court blessed in its final judgment had been hair color, then that would not run afoul of the statute, because you can still wear the protective hairstyle that the statute explicitly protects, but you just can't have it colored.
But if we take out intent or motivation or statements of legislators, and we're just looking at plain language, what plain language actually conflicts? What plain language says in the legislative definition or in the policy that you cannot have the braids or twists?
Absolutely.
Without them being a certain length?
I think the best response to that, Your Honor, is from the Texas Supreme Court, the Hogan decision that's in our briefing 2021 and Rath 2024. Courts must be, quote, cautious not to interpret silence in a way that undermines the statute's purpose. Here, the statute's purpose is to prevent school districts from enacting dress or grooming policies that prevent the wearing of a protective hairstyle, which is braids, locks, or twists.
Mr. Drummond, what was the citation you just referenced?
That's Hogan. It's 627 Southwest 3rd at page 169.
That Hogan and Zolani.
Yes.
And can I ask you a question?
Yes.
Is it correct that both parties agreed that the statute is unambiguous? That was the position that both parties took.
Yes.
And so I think you were in the process of guiding us. If this text is unambiguous, what we're able to look at or not. You were talking about looking at intent from the enacted language itself, not extrinsic evidence. What can you address in the actual act? And let me pull the language. So I do want to ask you a specific question about if you look at section 25902, section B.
Yes, ma'am.
Any student dress or grooming policy adopted by a school district, including a student dress or grooming policy for any extracurricular activity, may not discriminate against. How do we interpret what discriminate against mean in the context of this case?
The only evidence in the record as discrimination, and again, it's because this record was cut short because of the accelerated time frame the parties were required to comply with. There's evidence in Mr. George's sworn testimony. I believe it's page 1204, volume 4 of the clerk's clerk's record, where he testifies that other students were treated unequally to him, who had requested the same exceptions. They were granted exceptions. He was not, and so that is, again, there's not a robust record here. But the only evidence that exists, and this is a point that we made in our briefing, the only evidence in the record is that he was discriminated against on the basis of his protective hairstyle, which is
But what does discriminate against mean?
It means that he was forced to spend his entire junior year in school suspension.
Not as applied here, the plain meaning, in looking at the plain meaning of the words in the statute.
Well, discrimination has a robust history in law, both in federal law and state law. It's not defined in the statute itself, but here the discrimination that occurred was removing him from regular curricular instruction and being forced as a junior in high school because there's evidence from the Arnold case from Southern District of Texas that the teachers who were in school suspension were not certified teachers. And so the level of education he was forced to receive as a result of wearing the hair as it naturally grows out of his head and is protected by the state statute was subpar. That is also part of not only stigmatization, but the lasting impact that had on Mr. Arnold. It in fact forced him to transfer out of the school during his senior year of high school.
How do you respond to the district's position? I understand where your argument well.
Yes, sir.
How do you respond to the district's position that the policy, the school's policy, did not discriminate against the protective hairstyle in this case? Because Mr. George was nonetheless able to still wear locks, braids, or twists despite any length prohibition. And I want you to explain what you said earlier, so I want to make sure I understand. Are you saying there's testimony in the record that Mr. George would not have been able to wear locks, twists, or braids without the length exceeding at least below his eyebrows and below his earlobes? And
Absolutely.
Can you walk us through that?
The district has admitted both in briefing and in its sworn testimony that it confined him to in-school suspension for his refusal to cut his hair in order to comply with the district's policy. It's important to remember here that the only compliance that would work under the district's male hair length policy, because it has the when let down language, is to cut your hair. You can't just bind it up. You can't do anything else. You have to cut it, which raises questions because then that's forcing you to wear a hairstyle when you're outside of school hours, which I think also goes.
Is that in our? Is that before us? The question of whether you can force a hairstyle outside of
we've noted it in our briefing for sure, and I do want to note this too, because again, it's the same district, the same superintendent, the exact same language of the male hair length policy. If you looked at the Southern District's opinion by George Hanks, they found that this exact same policy, the same verbiage, was likely unconstitutionally racially discriminatory and pursued with a racially discriminatory motive.
Right,
so,
but that's a different claim, right? The question here is just statutory interpretation, and that's looking at, like, we could agree both that it's problematically discriminatory and potentially, in theory, that it complies with the statute or not, because those are different questions, right?
Well, when the question was posed as to what the discrimination was, I think it's at least relevant to note that the same verbiage of this policy applied to other black male students by the same district and by the same superintendent has already been found by a federal court and a former judge of this court.
Can I take you back? I'm sorry.
Yes, please.
Just saying, where in the record can we find evidence that you cannot have braids, for instance, unless they're of a certain length?
Well, that's the male hair length policy.
No. I'm sorry, not the policy. I thought you said it would be impossible to have braids.
Yes. So that evidence is from the sworn testimony of the legislators, both the primary author, Representative Bowers, and the other co-authors. I believe there's 5 or 6 affidavits, and Ms. Booker can speak to that better than I can. That is in the record where they testify. One, that we enacted Section 25 902, in response to the district, we enacted it to protect Mr. George, and that you cannot wear braids, locks or twists unless your hair is longer than what the policy allows you to wear.
Continue, sorry.
No, please. This is your time.
What language I, for one, don't think we should look at legislative intent. I think we should be looking at what the statute actually says.
100%.
So I'm trying to understand what record evidence you're pointing me to and what statutory language you're pointing me to. And you're talking about evidence from the legislators, and I don't know how that intersects, but maybe if it's evidence is...
It's absolutely not evidence of legislative intent at all. Right? It's evidence of the intent of the individual legislators who put forward their sworn testimony. Now, it should bear some weight since these are the legislators who were co-authors of the act that became the statute. But I think to focus on, and apologies if I'm not answering your question, you look at the hairstyles that are expressly protected by the enacted text: braids, locks, and twists. There's evidence in the record. It's post-legislative enactment testimony, sure, but it's still some evidence from folks who know that to wear a braid, lock, or twist, your hair has to be longer than what the district provides in their male hair length policy. And let me just read that so it's clear in the record. And this is what, again, was changed in the middle of the school year. The principal of Barbers Hill said he'd never seen that happen before when they added the when let down language. You can't wear a hairstyle that's gathered or worn that would allow the hair to extend below the top of the t-shirt collar, below the eyebrows, or below the earlobes. That's all it used to be prior to the middle of 2019, and then they added when let down. So you cannot bind it up to have it otherwise complied, because if you let it down, it would be longer than that which is permitted by the male hair length policy, which negates the ability to wear these hairstyles, which the legislature has said must be protected. Let me just offer.
So are you saying that there's a particular meaning to braids? It's not just braids. Protective hairstyle commonly or historically associated with race, and then protective hairstyle includes braids, locks, and twists.
Yes, sir.
And other things, because it says includes. But so the definition of protective hairstyle commonly or historically associated with race, are you saying that those plain terms necessarily include the length requirement, that it can be longer by its definition?
Again, that's not part of the enacted text. But in practice, as anyone knows who wears braids, locks, or twists, you cannot wear them unless you have hair length longer than what is permitted by the statute. So the reason why this is it's so much of an affront to the statute is that, again, if this had been an exception based on hair color or perming or something, that doesn't negate the ability to wear the hairstyle that the statute says you have a right to wear. The statute says that you have a right to wear braids, locks, and twists, but you can't wear those under the school district male hair length policy.
Your position is it is impossible to wear braids that would fit within the policy.
Yes, and as the affidavits from the legislators attest, because it's physically impossible to lock, twist, or braid hair that is as short as the male's hair length policy would require it to be. Let me just leave the court with another decision. This is the Morath case from 2024. I'm happy to give you a full site if you need it, Your Honor. It's in our briefing. Courts cannot construe statutes in a fashion which would frustrate or thwart the statute's purpose or effectively neuter the obligation imposed. That's exactly what this does. The male hair length policy frustrates, thwarts, neuters, and prevents anyone from wearing a protective hairstyle, because in order to do so, it has to be a certain length, which you cannot wear with the when let down language that is in the district's male hair length policy. I would want to just make one other note just quickly, and I know I'm way over time. I appreciate the court's indulgence. I do want to note, well, I'll save that for rebuttal in case the court has any other questions.
Do you have any questions? Thank you very much for your argument. We appreciate it. We're ready to hear from the district.
Well,
Okay, Ms. Booker.
Did you save it before? Oh, I'm sorry. I misunderstood. I thought you were saying it for rebuttal. Well, please, Ms. Booker.
Yes, thank you.
Thanks. My apologies.
Absolutely.
I'll be brief.
Yeah, take your time, please.
I'd like to start by saying this was a declaratory judgment, as we know, that was brought by Barbers Hill ISD. In the record, Barbers Hill ISD specifically requests that the court make a determination, not for just Mr. George, but for all students. They say that the district believes its dress code and grooming restrictions comply with the act and seeks a determination from this court to that effect. A declaration as to the application of the act is essential as the district seeks to avoid subjecting any students.
So what enables us to do that? What rule, how can we make a judgment as to non-parties?
Well, I would argue that a declaratory judgment in and of itself in a case of first precedence, although we do need a live controversy for collateral consequence, but we may need to open the gap a bit because at the end of the day, it would be right back before the court. What would we need to do? Have a student that is in the 9th grade bring that action, and would he be able to get here at that time? The problem is Barbers Hill ISD hasn't changed their grooming code. They haven't changed the application of the grooming code. And they've casted a wide net in and of themselves when they began the action to ask for all students. But I do believe that Mr. George does have a live controversy, given the fact that, I mean, we all go to high school graduations and we all go to alumni gatherings. We have high school reunions. Why? Because it's very important, the high school that you graduated from and the status that you had while there. He had to end up graduating from not a very good school. If you line them up next to Barbers Hill, and that's in the record, it is maybe a C school. When you come from a very nice school such as Barbers Hill, that is going to follow him for the rest of his life, because where you graduate from is going to change not only where you would go to school at, but it's going to be every job that you apply for from this point forward. So the controversy is live to that effect.
Does I return to where we started, did the consequences, it's clear there are consequences, but do the consequences have to stem from the judgment?
Your Honor, can you vacate a judgment and it still not have the consequences? Even if you vacate it, the consequences are there. I don't want to repeat what he said, but we already know about the Houston Chronicle ad. We know that this has been seen by everyone, and I believe just him having to go to another school versus cut his hair is what keeps it open, because he's had to change his entire life. And that is something that is going to have a bearing on every job application.
What is your best case for consequences of this sort you're discussing enable the dispute to remain live?
When you ask what is my best case?
The best case for us to look at, case law, not precedent for us to look at. What is the best one?
Well, you may not agree with me, but I mean, I would argue the grassroots case is a good one. I mean, because him graduating doesn't erase the ongoing harms, the unresolved legal rights, or the disputes over the policy itself. The declaratory judgment in and of itself requests means that the controversy is not just about what happened, but what the law is now and going forward. So I would say that that's a good case for us to look at.
Thank you.
Yes, ma'am. Just going to the case as a whole. If you go through, and I believe that Barbers Hill is going to talk about this, Retta Bowers and the legislators and the conversations that they had on the floor, they discussed being able to grow your hair. The point of a protective style is so that we can wear our hair long. It doesn't grow, and Retta Bowers discusses that, and that's in the record there, and she discusses it as to how she grew up and why her hair was never able to be long.
Do you agree that the record here shows, or that plain meaning definition as one would read and understand the statute shows somehow, either that it's impossible to have these protective styles with hair that's short enough to meet the requirements?
Yes, ma'am, because the purpose of a protective style, and Ms. Bowers talks about that, is so that, and that's why I believe they ran it underneath the race class, but that's neither here nor there for me. I kind of don't understand that portion of it, but I have to take it as it is. That allows us to wear our hair long. It allows us to be able to grow our hair so that we can have it below our ears and below the nape of the neck. Other than that, we won't be able to grow it long. So we lock it and we twist it. It will be in the record when they discuss that on the floor. Ms. Bowers herself, although she doesn't have locks or twists, she discusses that. on how her hair is natural. So it does all natural hairstyles.
But one couldn't in theory have short braids.
No.
That possibility doesn't exist.
This is the issue. You can't have short braids because they're going on the length of the hair. And in order for you to be able to braid hair, it has to be a specific length. You can't, I would argue, Mr. Gunn could not braid his hair. It's much too short, but his hair complies. So that's the only issue there. And then I would argue, and I'm not.
So the legislature could have said, we're going to protect your ability to have a protective hairstyle of any length or something like that, and they didn't. And your response is they didn't need to because
if you look at religious exemptions and you look at, and even off in the record, they've never needed to. A religious exemption will allow a Navajo Indian or someone of the like to be able to have their hair as long as it wants. That's why I believe that the case itself, when you get down to whether or not Barbers Hill ISD's grooming code violates, you can't have a law that's going to violate equal protection, and eventually we'll get there. Because if you're looking at religious exemptions and applying those one way and allowing a Sikh to keep his braid underneath the bun and not cut it, or you allow a Navajo to grow it as long and not cut it, and you allow religious exemptions, but this is a carved out exemption that has been given to us underneath the law, and you make them cut their hair. Now we're in equal protection land, which I don't want to go there.
But that's not, none of that is before us.
Yes, it is before you.
It is before us?
Yes, ma'am.
How is that before us live, a religious, a First Amendment argument? I thought it was not before us.
Because these are the arguments that Barbers Hill gave. So their argument was, we do recognize exemptions. We recognize a religious exemption, and that's the only exemption that we recognize. We allow Navajos, and we've had a gentleman that was a Navajo before, and we allowed him to have his braid long. But then they didn't recognize the Crown Act exemption. So they discuss how they allow exemptions. They only allow the religious exemption. They don't allow the Crown Act exemption the same pleasure. They make you cut it underneath the Crown Act, but they're both exemptions. And they're both meant to cover the hair. So technically you're taking something that, and I don't want to use the race card, I'm just saying, because it is, if you look at the way that it was interpreted, it comes underneath the race. Then you have essentially two strict scrutinies standing on top of each other. You're allowing a religion, you're recognizing the religious, but you're not recognizing, not so much as the race, but the protected style. Because it falls underneath race. And so because it falls underneath race, we don't have to use that term, we can use protected style. But nonetheless, it shouldn't be touched. You're not properly applying the law.
Any further questions? Ms. Brooker, were you able to cover your issues?
Yes, and then just one issue. I'm sorry, and I should have started with this with Exhibit 2. Just to let you all know what happened with that. We're going to go to the reporter's record. If you go to reporter's record, volume 4. If you look at reporter's record, volume 3, page 29, line 16, through page 30, line 21. We discussed exhibits a day before. And there was an issue with the exhibit, and Ms. Leon was supposed to provide a redacted exhibit, and we discussed that she's going to bring it the next morning, and I need to see it. I state in the record that I do trust her, and that I do believe that her version will be a good one, but I needed to see it first, and that she would be bringing that exhibit to court. I believe that she did bring that exhibit to court. We go on later, on the day of court, bench trial, which is going to be volume 4. Page 27, line 4 through line 25, where we then have that exhibit in. But physically, I did not have access to it. It would have been Ms. Leon. I don't believe that technically something that a legislator says after the act has been passed would be truly relevant, but it was a videotaped interview of Ms. Retta Bowers.
Thank you. Appreciate it. Do we know how much time we need to add? Total 30 minutes? Okay, very well.
Good afternoon. May it please the court. You all have asked a lot of hard questions already today. And I think part of the reason the questions are difficult before this court is because your record is very limited. And after the record closed and the appeal was filed, we've had a lot of additional information submitted to this court as if it were evidence that had been before the trial court when it was not. And I think that makes your job here today very hard. I wanted to start by addressing the mootness issue, but before getting there, I wanted to talk about several stipulations and waivers that occurred before the trial court that I think are significant. The first important issue for the court to understand is that the Georges non-suited their claims for discrimination prior to trial, and then stipulated to the trial court that the case is limited to a pure legal issue as to the meaning of the Crown Act. And so there was no testimony offered at all by the school district other than a couple documents relating to the policy. And
Can you help me understand this? Because this goes to the question I was asking about the kind of as applied versus writ large that I'm just trying to get my head around. So if everybody agrees the statute's unambiguous,
Correct.
then you don't look to evidence.
Correct.
But then, given the language of the statute, which looks at the protective hairstyle, how does one, is the question before us, are the two on a collision course kind of always, apart from the facts of this case, or is the question before us, given the concessions about his particular hairstyle was protective hairstyle, is it more as applied to him or a writ large question, and why in this case, and what empowers us to be deciding it either way?
This case was a facial challenge, I believe. It wasn't a challenge to the dress code at all. As pointed out earlier, the district initiated this lawsuit, which makes it a little bit unusual. And the reason why the district decided to take that unusual action is because of the intense public scrutiny of Barbers Hill ISD. And at the time the district made this decision, they actually had to shut down their phones for a couple of weeks because they were receiving so many death threats from people who supported Darryl George. And the school board decided, if we're wrong about our dress code, please tell us. And so we went before the trial court and said, please help us understand. This is a new statute. We've had this dress code for decades. The dress code is very similar to that used across the state of Texas in private and public schools. Hundreds of school districts have a similar dress code. If the Crown Act changes what has been the law in this state and in the circuit, that school districts can regulate the length of hair for boys in K through 12 settings. If that has changed, please tell us.
And Ms. Van, this was a declaratory judgment action, though. They requested the trial court to basically articulate the rights with respect to the parties before the trial court. So in essence, the court was able to grant declaratory relief, declaring the rights as it pertained to Mr. George at the time. Certainly you agree that we're not deciding how this policy may be applied in the future involving other children or other students that may have other issues. For example, if they have other type of protective hairstyles. We're just addressing the issue here, whether as to Mr. George, the policy was in violation of the act. You would agree that that's what we're deciding?
That is correct.
Okay, so help me understand then on the mootness issue. A collateral consequence that has been identified here, among others, is the disciplinary record that the school now has as it concerns Mr. George, and the very real possibility that that academic record may impact his future ability either to go to college or, I don't know, seek employment. I'm not sure. Why is that not a collateral consequence that allows us to reach the merits of the claim here?
I'm going to point the court's attention back to the Texas Department of Family and Protective Services case. Yes. If you'll recall, in that case, mothers of children who were detained in ICE detention complained about the conditions, including sexual assaults that were occurring where adults unrelated to children were in the same housing. And the Supreme Court said, once those parents and those children have been removed from the setting, there is no live case in controversy.
But as I understand the decision there, though, and I took great care to review that case because that was a suggestion of mootness that you felt was based. While I understand the judge, Justice Young, in that opinion, articulated the different type of exceptions, the exception that was applicable in that case was the public importance exception, right? Here, the collateral consequence doctrine wasn't really applied in that case. It was explained, but that was not the basis for the court determining that the case was moot there.
Correct. So, with respect to this particular litigant, he spent all of his K through 12 educational career in school districts other than Barbers Hill, except for his junior school year. So he came from the Goose Creek School District, he transferred or moved into the district, and then moved back to the Goose Creek School District where he graduated. When he's asked for records of his time in education, he's going to submit his transcript, which comes from the Goose Creek School District. The Barbers Hill records are just going to be the grades that he attained while he was there.
But he says he got worse grades because he was suspended, right? And then he also would have to answer, were you ever suspended? Yes, right?
That evidence is not in the record. Mr. George sat at the trial, he was present, he was able to testify. He did not testify at trial. After the court rendered judgment, he sent a post-trial affidavit in which he made certain allegations, but that's not evidence that was before the trial court. I didn't get to cross-examine him. We didn't get to test the veracity of that information. That's not evidence in this case that should be considered by this court.
How do you, for example, one of the cases on collateral consequences that was referenced in the grassroots case, it's a case involving juveniles, right? And the adjudication there, or the conviction of that juvenile in that case, potentially subjected him to the future possibility that he might have to register as a sex offender, or the future possibility that he might not be able to seek expungement of his record. So there was no evidence in that case that any of those efforts had been undertaken, yet the court found that the mere possibility that these issues may occur in the future rendered the case not moot under the collateral consequence doctrine. So help me understand, because I agree with you that there's some discussion in the grassroots case, or Marshall, that requires some evidence, but then we have other cases like Fitzkin and Ray ARC and other cases cited in grassroots where the courts did not consider evidence and consider the mere possibility of very real collateral consequences in the future.
My response to that would be simple. This is in-school suspension, the discipline that occurred here. So the transcript itself is not going to reflect anything other than the course taken and the grade earned. The school district actually worked with the George family to make sure he would keep up with his courses. He came to the district actually academically a year behind where he needed to be. And so they prepared an actual graduation plan that would accelerate his learning, give him all of the instruction that he needed. But none of that is going to show up on his transcript. What's going to show up on his transcript, the courses he took and what the grade was earned.
Help me understand, let's assume for this purpose, for this question, that there are some collateral consequences with some evidence supporting them. Are those collateral consequences, was the otherwise moot claim itself the source of those consequences or not? Because the grassroots case says the dispute remains live only if the otherwise moot claim itself, and itself is italicized, is the source of the consequences. So help me understand why or why not for the consequences that they're asserting. I understand your position that you say that there's not evidence supporting them, and that Marshall is your site on that. But assuming there are collateral consequences, are they from the claim that would otherwise be moot or not, and how do we analyze that?
So not only are we asserting that there's no evidence, but I'm also asserting that this court cannot assume that there might be.
No, but I'm just trying to understand to pretend a different case then where there are squarely consequences with evidence. I'm trying to understand this line in the grassroots case that says that the dispute remains live under the collateral consequences exception only if the otherwise moot claim itself is the source of the consequences. So what does that mean?
Yeah, we
I
haven't
haven't-
seen the word claim used in the case law like that. This is an unusual usage in our experience, so if you have input on it.
And I would have to speculate about what that claim might be, fit within that, but within the context of this case, Darryl George successfully completed the requirements for high school and has graduated. Perhaps if he had never graduated high school because of some stigmatizing impact from the application of the dress code that prevented him from proceeding in his career, perhaps that would get to what the Supreme Court is referring to.
But if he didn't graduate, then we wouldn't have a mootness issue here, because he could always be subject to the policy in the future, right?
He's aged out of public education.
So and maybe getting to this point of the claim itself, that what we're trying to maybe articulate, most of the cases that were cited by the district and by Mr. George on collateral consequences state that the collateral consequences have to stem from the judgment itself. However, in grassroots, there's language that the collateral consequences may arise from the claim itself. Do you see a distinction between that? In other words, collateral consequences arising from the judgment or arising from the claim itself, or maybe there is no distinction. We're trying to figure that out.
I think the best example of that is the one that you referenced, where you have a juvenile that has a criminal adjudication, and that record does follow you. Your criminal record does follow you. As a practical matter, minor disciplinary consequences that occur in a public school, they stay there. They don't go on your transcript. They don't become part of a larger record. I think the question was asked earlier, what if you were filling out the common application to go to college? I think the question is, have you been expelled from school? Not have you gone to in-school suspension for a dress code infraction.
And what about the lasting implications of the fact that he was sued by the district and that he lost that suit? Like, there is a declaratory judgment action out there that names him as a defendant in an action, basically stating that he was in violation of school policy for a year. And the lasting implications as articulated by Mr. Drummond in terms of the media and you know, the mental trauma and that both him and, as I understand the testimony from his mother, also experienced.
The school district initiated none of the media. The media initiated from Mr. George and his representatives, who started the media attack on the school district and their personnel, their leadership, well before the decision to find out what the statute means. The purpose for filing as a simple deck action with no other factual findings either way was to get a very prompt resolution. Now, what happened was it wasn't resolved promptly because the Georges added a bunch of claims, removed the case to federal court, then the federal court dismissed those claims, then we came back to state court, and so that dragged the matter on for several months.
But wait, why does that answer the collateral consequences question in any way? For instance, a typical example of a collateral consequence is if you are required to register as a sex offender.
Mm-hmm.
That's not, you just said, well, you didn't initiate the media. They don't initiate the same way the media was kind of independent, but was a collateral consequence, they argue. The fact that you have to register as a sex offender is independent, perhaps, or maybe not, I don't know, but I'm just thinking out loud. Why is the fact that you didn't call the media, why would that render it not a collateral consequence? Why does that answer us either way?
That the family chose to bring their case in the court of public opinion was a choice of the family. That is not a consequence of the school district's dress code.
But why does that's the question. The consequence of what? That's what we need to figure out for this mootness exception. Is it a consequence of the dress code that matters? Is it a consequence of the judgment that matters? Is it a consequence of the claim? What is it a consequence of, and why?
As I understand the court's opinion, there has to be something the consequence has to survive the mootness because there's a clear and concrete and ongoing harm to the litigant.
The consequence
because
of what?
Of the underlying, whatever was underlying in the claim. So if you were to take in the case of the parents of the people detained in the Grassroots case, and if those people knew they were going to be detained again, obviously they have a live issue, or if that detention were to impact, for example, their ability to lawfully enter the United States through the immigration system, that would be a collateral consequence. But I think the fact that something unpleasant happened while they were there, the court has said that is not a collateral consequence.
If he had been expelled, would that satisfy as a collateral consequence, and why? Yes or no?
You're asking me to speculate because we don't suspend
We're
students from school.
trying to understand. I'm
or
just trying to
expel.
understand the legal doctrine.
It's against the law to expel a student from school for a dress code infraction. So you're calling me to speculate beyond what I have thought about up till now. I think if I can't imagine a collateral consequence for a discipline based on a dress code enforcement that would be lingering and concrete, that would follow him after he's finished his K through 12 education.
Can I ask you just a factual question that I have? How does the district maintain disciplinary records? What would that look like? His in-school suspension? Is it a mark on a? You said it's not on the transcript. What is it? A file? How is that kept?
All school districts in the state are required to report to the TEA any disciplinary consequences and the Texas Education Agency. And the agency keeps that information for big picture purposes, for monitoring what kinds of discipline are happening around the state and those kinds of things. That information is submitted in an anonymous fashion. So it's 5 students went to in-school suspension for 10 days for dress code infractions. As to individual students, those records are generally purged at the end of the year for minor disciplinary consequences. And for any student, all school records, I think, are purged after 7 years.
What if there is an instance, I'm sorry I'm throwing hard hypotheticals at you, but what if there's an instance where it's a dress code violation, student suspended, and they can show track record? At the school, I was an A student before, and once I got suspended, I became an F student. Is that a collateral consequence?
I would respectfully offer to the court that those facts are not present here, nor are they in evidence. If a student had been unable to meet the college entrance requirements and otherwise had been on track for college and then was rendered ineligible, I think that question could be raised and that claim could be made. But those facts are not in evidence here, and even if the record were opened, I don't think those facts.
Okay, and do you have, coming back to my earlier question of collateral consequences of what? What is your position on what the law says on that? Is it the collateral consequence of the disciplinary action, the collateral consequences of the trial court judgment, the collateral consequences of something else?
The collateral consequences of the policy.
So what law says that? Because the cases I see tend to say of the judgment. What supports the collateral consequences of the policy that matter?
I'm just thinking about the court's reasoning in the Grassroots case, where they're talking about the challenges to the policy that the DPRS was using for placing students and parents, and how the housing was going to be applied. And the violation of that policy was the dispute between the parties, because unrelated adults were allowed to room together with children. So the application of that policy, if the policy actually permitted that, or the violation of the policy if the policy did not, that's the consequences, as I understand that decision.
So that would be your best case for us to review. You would rely on the Grassroots case as your best case on collateral consequences?
I would look at the Grassroots case and the Marshall case. I think that's also I think, instructive to the questions that you're asking here. In that case, the plaintiff was about to be evicted from their home, and the lasting consequences were going to be that could impact the ability to access debt credit in the future and get another lease and those sorts of things. And that was deemed to be not sufficient to raise that lasting and concrete harm arising from the underlying.
Let me ask you about that case. I agree with you. I read it carefully because I'm trying to figure out how this case and the facts fit within Marshall or Grassroots. In Marshall, the reason that there were no collateral consequences remaining is because the actual judgment of forcible detainer was vacated. And so the collateral consequences there was that the appellant was going to lose her federal rent subsidy if there was a judgment cast against her for forcible detainer, or that future landlords potentially would not be able to lease in the future. So by vacating the judgment of possession or forcible detainer, then the appellant was not subject to losing her federal subsidy. So we have resolution, right? By vacating the trial court's judgment, that appellant would no longer face potentially those collateral consequences. I'm trying to understand here, if we find that the case is moot and we vacate the lower court's judgment that the policy is in compliance with the act, I'm having a hard time understanding how that would ameliorate or resolve any presumably established, because I understand you're raising an issue as to whether there's evidence of any collateral consequences. By vacating the judgment, I'm not understanding how that resolves the lasting implications that the student was in violation of a policy, and whatever implications may come from there.
I think in order for the court to reach the conclusion that there are some sort of lasting consequences from a school-aged child violating a student dress code, I think that's a difficult assumption to reach. We are talking about really, I understand it's an important case, and the parents and the student feel strongly about it, but these decisions are made in schools every day, and school administrators are on the front line of making those really hard calls. But at the end of the day, although you may have very strong feelings about it, it doesn't mean that it has lasting and concrete and tangible implications.
Your point being that they're speculative at best and not concrete, and we don't know that it actually is going to have the kind of implications that are being intimated in this case.
Yes.
But help me understand this. So I'm still, this sentence, two sentences I keep going back to from Grassroots that I'm trying to get my head around. If the consequence would exist regardless, then the case remains moot. So we have to understand, if the consequence, I understand you're saying that the consequences they're alleging are hypothetical, not supported, but they're disagreeing with that. And I'm trying to understand what the legal framework is. And it says if the consequence would exist regardless, then the case remains moot. So here, wouldn't the consequence exist regardless? The consequences of the result of this suspension, but not as a result of the trial court's judgment, then whatever we do, whether we take the case as, if we had a way to say it's not moot, or if we had a way to say, how do the consequences not exist regardless? So it says, I'll read it again, but a dispute remains live under the collateral consequence exception only if the otherwise moot claim itself is the source of a sufficiently concrete collateral consequence. If the consequence would exist regardless, then the case remains moot. So what they're saying is, well, I'm hopeful you'll help me understand what they're saying, but what I read them to be saying is that essentially if the claim that we could then adjudicate is the source of the consequence, then it's not moot. But if the consequences exist regardless, it is moot. Let's imagine a world in which it's not moot and we were to reverse here. In that instance, wouldn't the collateral consequences that they're arguing still exist? And isn't that a problem for mootness? Yes or no?
No, I believe the court is saying that in order for this court to have a justiciable claim before it, there must be something that changes as a result of your decision. You're changing some material condition that is suffered by Mr. George. And what I'm saying is there's no material condition, no concrete condition that he's experiencing now that would change if you exercised jurisdiction and offered an opinion about a dress code policy that no longer applies to Mr. George.
Ms. Van, can I direct you to the merits of the
Yes.
case?
Thank you.
Can you address, I think it would be very helpful because I think it's important to you address the specific stipulation that was made by the district. And let me tell you how I understand it because I want you to tell me if I'm wrong or if I'm right on this. As I understand it, the district made a stipulation that the hairstyle that Mr. George was wearing is a protective hairstyle traditionally, historically associated with race. Was that a stipulation that was in fact made by the district below?
There was. The district assumed that the statute was valid. We did not challenge the statute. I would point out it's a little bit curious to have a statute that applies to only one racial group. So the district believes it has to apply to all students, and not just students who have certain hair textures. And the statute says you cannot.
It says hair texture. Sorry, continue
Sorry.
on. Continue on.
And the statute says you cannot discriminate against people because of those hair textures. So assuming all of those things are valid and lawful, our question is it discriminatory per se to enforce our hair length policy for boys, which is something that's been in place for decades. And the courts in the Texas Supreme Court, the Fifth Circuit Court of Appeals have reiterated time and time again that this is the kind of policy that schools in their role as in loco parentis can enforce.
But that's a different question, right? I understand the position. And of course, in the federal cases, that was the position of the district, that they have a legitimate interest under the intermediate scrutiny standard that the courts applied. But the question for us is we can't go into that, right? I understand that there's implications and on both sides of what the statute and the claims arising from them, involving discrimination claims as traditional discrimination claims. Those issues are not before us, right? So the only question is whether the act as passed protects the hairstyle, the protective hairstyle that Mr. George was wearing when the policy was in place. And so the reason I asked about the stipulation is because as I'm looking at the statute, if the district agrees or stipulated that the hairstyle that Mr. George was wearing when he was at the school district is a protective hairstyle, then I don't see an exemption that is written into the statute that would allow then the district or walk me through it, what I would like for you to respond is to Mr. Dorman's argument, is that by imposing an exemption for hair length restrictions, you're asking us to write words into the statute that are simply not there. It's a wholesale protection of protective hairstyles under the act.
Right. So the school district has always permitted the wearing of braids or locks on its students, regardless of race, subject to the hair length requirement. And they, as Mr. Drummond pointed out, which is also not in the record, but just to give you some factual basis, the district added the term when let down to clarify that the purpose of this hair length regulation is to keep hair from getting below the collar and below the eyebrows. So if a student presents at school, as Mr. Drummond's exhibit shows, and the hair is not below the eyebrows and not below, and it's not let down, the school district, it's not a violation of the policy. If the student presents at school with their hair below the eyebrows, which is how Mr. George, this is how Miss George identified this as her son at school. his hair is below his eyebrows.
But Ms.
So
Ian,
now
the
school
position the
officials-
district court below was not that. It was that even if his hair was collected, it was a violation of the policy.
It's a violation if it's too long, but as I said, when a student walks into school every day, the administrator has to make that judgment call. And if the judgment call is, I don't see that the hair is too long, we're not going to ask him to let the hair down.
But that's not we're looking at the
Yeah.
plain terms of the statute. So I come back to my question that I asked the other side. Does this record show, or does the plain meaning definition show, that it's impossible to have braids that meet your length? Yes
No.
or no? And
No.
and then my broader question is, you said that you asked for per se ruling. I'm again trying to understand, is the question before us, can the policy violate the statute? Meaning, could there be some instance in which it does? Is the question, in this particular instance, does the policy violate the statute? Or does it always
Yes.
violate the statute? Which is the question we're answering, and why?
You're asking the second question. So we could violate the statute by allowing another student with braids that are too long, that is a male student, we'd let that person, assuming that student had a different race, allow that student to proceed into the schoolhouse doors, and stopping Mr. George because of the texture of his hair, or the fact that the nature of his hair is associated with race, which is just
But what
nothing more than
if
racial
your
discrimination.
concession here, you conceded here that he had a protective hairstyle braids, but there was nothing, as far as I can tell, in the concession about length. What if your concession here was that the length was part of what was protected? Then does the policy violate the statute in that instance?
That's what we were asking the court. Does this statute protect length? We're reading the statute. We don't see that it protects length. We're asking for clarification.
Right, but here you have a concession that he has a protective hairstyle. But you don't concede that the length is protected. You're saying just what's protected is the braids.
Correct.
Correct? Okay. So my question is, you said that you asked the trial court for per se determination about the policy and the statute. So I'm trying to then understand, if there was a case where there was a concession, that in that case length was what was protected. That was what was protected was length. In that case, the policy would then violate the statute, right?
If the statute prohibits us from having any hair length requirements, then our policy would
That's
be
not what I'm
violative.
asking. Is it, okay.
That's why we asked the
Protective
question.
hairstyle is defined to include specific hairstyles, but it
Right.
has the word include, so there could be others.
Right.
What if there was a case where the person could prove that having hair to the ground qualifies as a protective hairstyle? Then is the policy
If
invalid?
that hypothetical fact were, if that hypothetical were true, if the statutes, if the application of the language of the statute means that you could never require anyone to modify the length of their hair, then we shouldn't punish the students, and we should change our policy. And that's why we asked the question.
Okay, and what does a braid mean?
What does a braid mean?
Right. What does it mean? What's the plain language definition?
I haven't.
And let me actually make sure I'm very specific. A braid or lock or twist commonly or historically associated with race. What do those terms mean?
I'm not qualified to give you expert testimony on
I'm not
how
asking for
they're
expert
forming of the
testimony. It's
hair.
our job when interpreting statutes to apply
Right.
their plain meaning. The question before us is statutory interpretation. The plain meaning, what does it mean when you compare the two? So what do those terms mean?
I think there are three different manners in which people with afro-textured or curly hair, what do I say, draw the hair together to protect it from drying out, or from becoming frizzy, or just to keep it neat.
And your position is they have nothing to do with length. You can have them
That's right.
regardless of the hair length.
Well, it has something to do with length. At some point, your hair gets very long, but does it mean that you can't have braids that are shorter? Absolutely. We have dozens of students with braids, with locks, with, you know, different kinds of hairstyles that would be, I think, considered protective, but they keep it within the length requirement and maintain their protective hairstyle at the same time.
Yes, Leanne, I want to touch upon something that you said before because I want to make sure I understand it. So is your position that we need to focus on whether there was discrimination in the implementation of the policy? What you're saying is so long as we treat everyone the same, and we're not requiring just, in this case, Mr. George or other people who wear hairstyles that way, that your position is that you're compliant with the policy if it's treated across the board. In the way that the statute was written, I'm looking at specifically section B, and it says that any policy adopted by a school district may not discriminate against a hair texture or protective hairstyle commonly or historically associated with race. In order for Mr. George to have been compliant with the policy in this case, he would have had to cut his hair, as I understand it. Is that not then, at least as applied involving his situation, does the policy then not discriminate? Because it's curious the language that was used here. It's discrimination against a hairstyle associated with race. It doesn't talk about disparate discrimination as we typically see it when we're reviewing discriminatory practices in other contexts, right? It just generally, as a whole, protects this hairstyle. And so why then would, in any instance, any requirement that would have required Mr. George here to cut his hair not be discrimination based on his protective hairstyle under the plain terms of the statute?
The United States military, Army, announced yesterday that they're modifying their dress and grooming policy for their soldiers. The U.S. military is an employer. The Houston Fire Department is an employer, and the employers have the same restrictions as part of the same act of the legislature. And I think the reason why we're all struggling with that is because some employers must require shorter hair, whether for OSHA, whether to comply with U.S. military guidelines, whether health and safety reasons related to
me,
the
I
employment.
think this is getting to a different question. We don't have before us if this is a good or bad policy. We don't have before us if this policy discriminates. We just have, is this policy in violation of the statute? So can you focus your answer on
Yes.
the specific terms of the policy and statute?
I presume that when the legislature enacted the statute, it was aware that some school districts have, as approved by the Texas Supreme Court, policies that limit hair length for male students around the state of Texas. I assume that the legislature would have said something about length if it intended that. I think it needs, I think
It
that
could have said something about
it could have and didn't. And it's met 3 times since the judgment came out in this case. We had 1 special session, or 1 regular session, 2 specials. And they have not come back and clarified.
What about the inverse of that? The fact that they said nothing, isn't that an affirmation that they did not intend to limit the application of the act? In other words, that it was subject to no exception. Can we interpret it both ways, the silence of the statute in this case?
In order for you to do so, I think that you are reading language into reading
What
intent
language?
into the statute and not reading the words. I think it's improper for the court to go into any kind of extrinsic evidence or interpretation, because the language of the statute, we've all stipulated, is clear on its face. And so, and it does not speak to length, and I think that's intentional because it applies to both school children and to adults.
Yeah. Mr. Drummond stated that by creating an exemption for hair length, you would be reading words into the statute. How do we respond to that?
I had a difficulty understanding that argument to begin with. So an exemption for hair length, reading it into the statute.
In other words, if I'm looking at the policy here, right? It says any policy adopted by a school district. It doesn't say any policy adopted by a school district other than a hair length policy may not discriminate against a hair texture or protective hairstyle.
So,
I think that was his point, that it doesn't exclude, it says any policy, it doesn't exclude hair length policies.
Right. There are a number of policies that school districts implement. Think about the marching band. You know, the band director may have a different requirement about the hair length for the students marching because of the uniform. I mean, school districts implement policies that are both formal and informal all the time. And I think what the legislature was saying is, across school settings, you cannot treat people with a certain texture or style of hair in a worse manner than you treat other students. That's what it says, and I think that's right.
And so explain why your policy doesn't do that.
Because so long as the students wear their hair within the hair length guidelines, which are not strict, you know, a t-shirt collar is way down here. But there's some pedagogical reasons why you don't want children wearing their hair over their eyes, for example. So, you know, we have many students who wear their hair in protective hairstyles at Barbers Hill ISD, and they do so within the hair length policies, and so the policy does not conflict with the statute.
Question.
So, and that's, go ahead.
The word protective, it's a word I don't see in many statutes. What work is that doing? Why protective?
It's interesting. The statute is originates from some work done by Dove, the beauty care industry, and some other people who wanted to celebrate natural hairstyles primarily for African American women. As I understand it, just from their website, you know, African American women have difficulty or you know, don't always want to straighten their hair or resent that. And also when they grow their hair, it can get dried out. And so it's protective to braid it, so it's not exposed to the elements, not exposed to being dried.
Fair enough. Then the other word that interests me is hairstyle, because I think what I'm hearing is both of you read the word hairstyle in a different way.
Yes.
And then you say it does or doesn't have length included as a component. I think I hear the appellant saying part of hairstyle can be length in this particular setting, and you're not respecting that. And I hear you say, I don't care about anything else. I just care about length. I don't care about hairstyle. You can have it. So I think that one word, hairstyle, becomes sort of the pivot point where the merits come to a head, right? And so we've got to look, okay, how do we define that? It's not defined.
It is defined.
And
Protective hairstyles.
I think the word includes doesn't define
Right.
it.
Okay.
I think it tells us some things that belong there, but it leaves us at sea on what else might
Right.
belong there.
Right.
And so then we look at, you know, the things in the Code Construction Act and the context, if you will, which there's not a whole lot of guidance, whatever we look at.
So I think that's a really good question, and I think that's why everyone has struggled with the statute. The statute is something that has been promoted across the U.S. and as a federal mandate. So it was put before Congress as a model statute to apply everywhere. Only a couple dozen states have applied it. The United States Congress has not adopted it. But it is sponsored by, again, non-legislative bodies. It's sponsored by Dove and the Urban League Association.
But we don't have court decisions from Oklahoma and Colorado and the Fourth Circuit and so on.
We're starting to get them because they just, this has been a trend across the nation. And I found, when we went to trial, I couldn't find any other cases that were helpful. In preparation for this argument, I found two. One is out of the Northern District of Texas, and It's, can give you a citation, it's Thompson versus Bacon Nation, and it was an employment discrimination claim. And they didn't get to the heart of the Crown Act, but the employee in that case said, I'm being discriminated against in my employment because I wear a protective hairstyle, and so therefore I'm suing under the Texas Crown Act. And the Northern District, and this just came out on July 31st of 2025, the Northern District dismissed the claims that determined that the terminated employees' Crown Act claims were futile, but in doing so looked to standard discrimination law. So looked to Chapter 21 of the Labor Code and the balancing interest there. And then in New York, there was a case involving an inmate. And again, the inmate's claim said that the guards had threatened him because he wouldn't cut his hair, and he asserted a claim under the New York version of the Crown Act. And that case is called Moore versus McCann, and I can submit that to the court after. But it says basically that just violation of the Crown Act standing alone does not give rise to a claim for discrimination. Again, looking to federal discrimination law to interpret that one term in the statute, discrimination, which
Does
is
the
what we're looking at.
TEA have any, has the TEA given us an administrative interpretation of the word hairstyle or the phrase protective hairstyle?
The TEA did have this very matter put squarely in front of it by the Georges, and because of some procedural errors in bringing it, it dismissed it for failure to exhaust administrative remedies. So we don't have a finding on the merits from the TEA, but contrary to counsel's assertion, this is exactly the kind of claim that TEA does have jurisdiction over under the Texas Education Code.
Any further questions? Thank you very much. Appreciate it. That
Thank
was
you.
a fire drill. We really appreciate lots of questions. Thank you. Mr. Drummond?
Thank you, Your Honors. I've never responded to 50 minutes of argument before, so I'm going to move fast. If the court will allow me just a little leeway, I promise I will not abuse it. I'll just try to rifle shot this to address a couple matters. First, as to Justice Coey's question about is it impossible to wear braids, locks, and twists, which are the defined terms that are included in the statute as protective hairstyles, yes. The only evidence in the record are the affidavits of the authors of the act, and that's the only evidence. There's no countervailing evidence that says it's impossible to wear braids, locks, or twists.
What about the plain meaning? What if we're looking at this, what if we're not looking at evidence in this case, if we're saying that the statute's unambiguous? How are we to determine the plain meaning of protected hairstyle to determine if that includes length or not?
There's no exposition in the words of the statute itself. There just isn't.
What about dictionary definitions? Where are we to look to determine that?
It did occur to me that you're not likely to find that definition in blacks. But yes, there are dictionaries. We're happy to submit some post-submission briefing if the court prefers and have it responded to on where the court could go to find some common definitions of braids, locks, and twists. One, to understand those hairstyles, and two, to understand why they have to have a length that is long enough in order to wear them. But just to answer your question, yes, that evidence is in the record. I understand that you have qualms about looking to the evidence, but it's there, and it's the only evidence.
Perfect.
Also wanted to address, the district said that their male hair length policy has been around for decades. That's inaccurate. They changed it to add the when let down language in 2019. They also stated that they would never expel a student for wearing their hair that violated the code, but what they would do, when this is in the record, is threaten to transfer their student, Mr. George, to the DAEP alternative campus, which is where they send felons. It's where they send folks who've been convicted of sex crimes, of drug crimes. So for wearing the hair as it grows out of Mr. George's head, that's where they threaten to send it. That's in the record. It's an email from district personnel.
You're saying that's a collateral consequence?
Yes, but also just to correct a factual inaccuracy that the district made in their direct argument. There's a question about grade suffering. The only evidence in the record is from Mr. George in his sworn testimony that said his grades did in fact suffer. There's no countervailing evidence. And let me go to that as well. The district also said that his affidavit was submitted after the final judgment. That's incorrect. His affidavit, which is in the record, pardon my blindness, page 1204.
Is that 1203, 1204?
Yes, yes. It was executed on January 19th of 2024. That's a month prior to the hearing on February 22nd, 2024, and 2 months prior to the final judgment.
What's your best case for that qualifies as the type of collateral consequence that keeps the dispute here alive?
Well,
Do you agree
again,
it's the grassroots case?
we have several. I think that there's nothing new in grassroots except that it disallowed the public consequences exception. But we rely more on Marshall.
Isn't Marshall somewhat bad for you though? Because Marshall, the woman has an argument that she could be harmed in the future because people wouldn't want to rent to her, and the court says that's too speculative and you don't have specific evidence in the record about that, about the future people not renting to you. Why is that not, why does Marshall help you on that?
Well, again, in my very limited time, I don't want to go back into what we've already heard, but Marshall stands for the proposition that both as to stigmatization and as to when there are concrete disadvantages or disabilities. We think there's ample evidence of that here.
Mr. Drummond, can you briefly
Yes.
address the argument that the policy only prevents discrimination, in the sense that it's the discrimination by treating people disparately? As long as the policy is applied equally across the board, then regardless of whether Mr. George was wearing a protective hairstyle, there was no discrimination.
Again, I think that assertion is belied by the evidence here. The only evidence in the record as to unequal treatment is the affidavit of Mr. George, which says he was treated differently from other students who wore the same hairstyles.
We don't have a factual finding from the trial court on that issue. What do we do with that? Because we're reviewing, the findings of fact do not address whether there was discrimination.
That's true, Your Honor, but because there's a reporter's record here, the court can't presume the evidence supports either the factual findings or the judgment. It has to look at the evidence in the case, which is why I keep harping on it. The only evidence here goes to what we are asserting. I do want to address, there was a mention about whether or not this only applies to one race. That is inaccurate. It applies to every race, every student of every race. But I will note that it is not a coincidence that the only litigation that the district has been involved in on this issue has been against 3 black male students. I don't think that happened by coincidence. Let me mention this just very quickly, and I wanted to wait to see if the district addressed it in their direct. We noted this in our reply brief. There's been no argument, zero, from the district to counter our Code Construction Act argument that Justice Gunn had brought up. There is a provision in the Code Construction Act at 311-028. This is in our main merits brief. A uniform act included in the code shall be construed to effect its general purpose to make uniform the law of those states that have enacted it. Also, Texas Supreme Court in 2011, the half-price checks case, the Uniform Act should be construed to promote uniformity with other jurisdictions here. And again, I think the district inaccurately said there's a couple dozen. There's 27 states as of the time that we filed our reply brief that have adopted a version of the Crown Act. Now it's up to 28. None have a hair length exception. None. So if this court would...
But have there been cases looking at, are there new cases beyond the 2 that we just heard about? Are there new cases for us to go look at?
So as to the cases that the district has identified, those don't deal with hair length either. So I don't think they bear upon this case. Plus, they don't even involve students.
So how did those other state provisions help us interpret whether whether hairstyle includes
Right.
length or not?
Well, because you have an obligation, and it's not there's actually no discretion. It shall be construed to effect the general purpose, which is protecting hairstyles that are commonly historically associated with race, including braids, locks, and twists, to make uniform the law of those states that have enacted it. Because there's no other state that has recognized this purported exception for hair length, if this court blesses the action of the trial court, it would make Texas the first state that has looked at the Crown Act statute to recognize.
We wouldn't be recognizing an exception. What we'd be saying is that the policy doesn't conflict with the language.
I disagree, Your Honor.
Why?
The language of the final judgment, finds fact, and particularly the conclusions of law expressly says that Because the statute is silent, I can, as a judge, write in an exception that wasn't passed by the legislature to create a hair length exception.
But
So I think to answer your question, Your Honor, if this court allows that judgment to stand, that's the juristic effect of what this court would be doing. So even if the court doesn't write on it, it's allowing that to stand. It's creating a hair exception in law, in a decision in Texas that doesn't exist in any of the other majority of the states in the country that have.
Pick a state. Which state would you win in? I mean,
I think we win in every state
Colorado?
because there hasn't been a single state that has recognized a hair length exception.
Is there a case that says you win in that state?
No.
I mean, it sounds to me like it's going to be a Star Trek going where nobody's gone before, and whoever wins.
Well, I would disagree because again, the court doesn't have jurisdiction to not construe in a way that is consistent with other jurisdictions. That means there has to be a decision that recognizes a hair length exception in another jurisdiction for this court to follow that. That doesn't exist. It hasn't been brought to your point, Justice Gunn. There's probably a pretty good reason why it hasn't been brought, because people know who work in this space, who have passed these laws, to wear braids, locks, and twists, it has to be long enough in order to do it. I do want to make just one brief closing statement, if the court will permit me, about a minute.
Please, yes.
I will leave this court with statements from three individuals that are in the record and are in briefing. First is from our governor. After signing Section 25902 into law, he stated, "No Texan should face discrimination based on their natural hair." The Georgians agree with the governor. And when the statute's primary author, Representative Bowers, when she laid out her bill in 2023, prior to its eventual passage by margins of 141-3 in the Texas House and 29-1 in the Texas Senate, she offered this: "I believe how the hair naturally grows out of our heads should have nothing to do with what is inside it. So I'm asking every one of you to stand up with me against what is wrong and to stand up for what is right." And finally, perhaps the person who expressed it best is Mr. George himself, who pled with the court below in his affidavit, "Please help me. Throughout the history of this case, both Mrs. George and Mr. George have been pleading for someone to do what is right, to help him, to help her son. No one has. So we are before the court today. We respectfully ask the court to do what neither the district nor the district court has done below, to stand up for what is right, answer Mr. George's plea to help not only himself, but the students that follow behind him, and Mr. Arnold and Mr. Bradford, as students in the district. So we respectfully ask the court to reverse the final judgment below and render declaratory judgment that the district's male hair length policy impermissibly violates Texas Education Code Section 25902. Thank you.
Thank you very much. Thank you to both sides for your very excellent arguments. We really appreciate it. It was very helpful for our purposes and our discussion of this case. We thank everyone for being here. We appreciate the party's guidance, and this case is now adjourned.
All rise.